for having me here tonight. And thank you, Jan, for the nice introduction. So just a little bit more about what our service does. So we do a combination of three things. So we give free advice and representation, community legal education, and law and policy reform work. So we prioritise women who are disadvantaged by their social, cultural and economic circumstances, and we provide specialist legal services relating to domestic and family violence, sexual assault, family law, discrimination, victim support, care and protection, human rights and access to justice issues. So one of those specialist services that we operate is the Working Women's Legal Service, which provides free legal advice and representation to women who have experienced discrimination and sexual harassment in the workplace. So we established this service in 2013, concerned that women were unaware of their legal rights and where they could go for free legal advice if they had been sexually harassed or discriminated at work. For those women who were filing complaints of discrimination and sexual harassment, we were concerned that they were doing that without the benefit of getting some legal advice. We now have a good working relationship with the New South Wales Anti-Discrimination Board and the Australian Human Rights Commission, who often refer us vulnerable complainants for further assistance. We were also aware that assisting women to resolve their workplace disputes would also help them hold on to their financial independence, which is often key to them being able to leave violent relationships. So we also do some law reform work around women's workplace rights as well. So we just very recently contributed to an inquiry into whether Australia should have a modern Slavery Act, lobbying the government to introduce more accessible mechanisms to allow women who have been victims of forced labour to be compensated for the work that they've performed. So I'm sure you're all aware, but we've had anti-discrimination legislation in Australia for some time now, about 25 years, state and federal. And just for clarity, and because lawyers like definitions of things, unlawful discrimination means to treat someone less favourably on the basis of a protected attribute, such as carers' responsibilities, in a particular area of public life, so the workplace, for example, or to require someone to comply with a requirement or condition which a substantially higher proportion of a particular group cannot comply, and which is unreasonable in the circumstances. So that means that it might be unreasonable to require carers of school-aged children to work 9 to 5 in an office environment. There are some exceptions, though, to those laws. So organisations established to propagate religion may be able to discriminate against someone if the act or practice of that organisation conforms to the doctrines of that religion, or it's necessary to avoid injury to the religious susceptibilities of the adherents of that religion. So it might be lawful for a religious school to fire a woman who's single and pregnant. So sexual harassment, I'm sure we all know what that means, but it's basically conduct which is humiliating, offensive, embarrassing or intimidating. And so examples could include, your boss making comments about your clothing or your body, being exposed to sexually explicit material at work, being groped or being sexually assaulted. So despite the laws in Australia, a significant proportion of women continue to experience sexual harassment and discrimination in the workplace. So the Human Rights Commission, which handles discrimination complaints made under Commonwealth laws, reported that in 2015-16, 20% of all complaints, so a little over 400, that were made under the Sex Discrimination Act were made under the Sex Discrimination Act, and 82% of those were in relation to discrimination at work, 15% were in relation to pregnancy, breastfeeding and family responsibilities, and 22% of those complaints were in relation to sexual harassment. So according to a survey that the Human Rights Commission did in 2012, 21% of people had been sexually harassed in the past 5 years, and 68% of those people had been harassed at work. The survey also found that 1/3 of women surveyed had experienced sexual harassment compared to 1 in 10 men. According to the 2012 personal safety survey conducted by the ABS, 17% of women had experienced violence by a partner since the age of 15. So considering those statistics, many women have likely experienced some sort of sexual violence in their public and private lives. In my experience, women feel incredibly conflicted about what to do when they've experienced discrimination or sexual harassment. Women often feel stressed, intimidated and scared about the way that they've been treated, and are worried that if they complain, they'll get fired or they'll lose their shifts, or they'll be further victimised for making a complaint. And those fears are often warranted, because that's exactly what happens to a lot of women who do complain. Some groups of women are particularly reluctant to complain about discrimination. Young women are often keen to hold on to what might be their first job. Women living in rural, regional, remote areas may not have many other job opportunities. Pregnant women often find it hard to get another job in the lead up to the birth of their child, and lose their rights to return to work and other financial support if they're not in continuous employment for a particular period of time. Carers of young children want to hold on to jobs that give them flexibility, and older women fear not being able to get future employment. So when women lose their jobs due to sexual harassment and discrimination, the impact can be catastrophic. So one of my clients was a young woman who was earning a good income, living by herself in a rental property, and had an active social life. When she told her employer that she was pregnant, they stopped giving her shifts. She had to move in with her parents. She sold all her belongings to pay for outstanding bills. She stopped socialising and considered having an abortion. She became depressed and said that she felt so ashamed of having to rely on her parents for support after being so independent. So sexual harassment and discrimination can impact a woman's confidence as a worker, and can affect her ability to gain future employment. Women often decide to leave an industry that they've enjoyed working in. Women who gain new employment may be less inclined to report sexual harassment or discrimination in the future, and experiencing sexual harassment in the workplace can re-traumatise women who have experienced sexual violence in their private lives. Women who lose their jobs can then be at risk of losing their housing, which can then put them at risk of losing their children to state intervention. So those women who are brave enough to complain about discrimination or sexual harassment may have the option of being able to follow an internal dispute resolution process, set out an internal workplace policy. If there isn't a policy, or if they're not satisfied with how their employer dealt with their complaint, they may be able to complain either to the New South Wales Anti-Discrimination Board, the Australian Human Rights Commission, or the Fair Work Commission. So the New South Wales ADB deals with complaints made under the New South Wales Anti-Discrimination Act. It's free to complain, and the ADB tries to help parties resolve their complaint through facilitated conciliation conferences. We often represent particularly vulnerable women in conciliation conferences and try to help them resolve their complaint, either through reinstatement, compensation, an apology, or an agreement that their employer undergo training. If the complaint can't be resolved, then the woman can elect to have the New South Wales Civil and Administrative Tribunal resolve their dispute, and parties usually pay for their own costs. A complaint to the Human Rights Commission is handled in the same way, except if a complaint can't be resolved, the option is to have a federal court make a decision. But the unsuccessful party is usually responsible for paying the other party's costs, which is a huge disincentive for anyone to pursue their complaint beyond the conciliation process. Alternatively, women could may be able to lodge an unfair dismissal complaint or a general protections complaint with the Fair Work Commission, which handles complaints under the Commonwealth Fair Work Act. Complaints are handled in a similar way, except there's a fee to complain, and if the complaint can't be resolved, a federal court can make a decision, and parties usually pay for their own costs. That said, very few complaints made to the ADB, Human Rights Commission or Fair Work Commission are litigated, which means the majority of complaints are either resolved or discontinued at the conciliation phase. Some of the benefits of resolving the matter at the conciliation stage is that women have some control over the outcome of their matter, often walking away with something that they can live with, rather than rolling the dice at court and risk having to pay their employer's costs. Women are often reluctant to talk about their experience of sexual harassment in a public sphere, and conciliation gives them an opportunity to discuss what happened to them in private. While women often feel anxious in the lead up to a conciliation conference, they often report feeling empowered after it because they've had the opportunity to tell their employer and perhaps their co-worker about how the treatment of them made them feel and required their employer to account for their behaviour. So an obvious downside of resolving discrimination and sexual harassment complaints at the conciliation stage is the confidentiality of any agreements that are reached. This means that the outcomes do little to create systemic change and don't create case law. At most, it might persuade an individual or an employer to act differently in the future. The outcomes in conciliation can also be limited. So often the employment relationship between the parties is so damaged by that point that reinstatement or even ongoing employment is unrealistic. Compensation can also be limited. So the imbalance in power between employees and employers, particularly when an employer's aware that a woman can't litigate a matter, means that women are often in a position where they have to accept whatever the employer is willing to offer them, which is often nothing. So what I think we really need is a shift in the way that men, employers and the community think about women. Sexual harassment and discrimination on the basis of sex, pregnancy and carers' responsibilities is inherently a gendered issue, which arises from men's lack of respect for women as workers, carers and people. Women with children in the workforce continue to face the struggle of balancing their responsibilities and identities as carers and workers. All of that said, and despite being a lawyer, I remain an optimist. The fact that I'm standing here tonight as a professional talking about women in the workforce is a testament to how much things have changed in the last century. I'm constantly inspired by women's willingness to stand up to men and often huge corporations and demand that they be treated better and fairer. It's these women that help create better laws, policies and a world for the rest of us. I have hope that if we keep talking about these issues and agitating for change, that the workplace will be a better and safer place for all women in the future. Thank you.